Good morning. Welcome to the Long Live Third Parties podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Matter of McGuire versus Gamache, 840-NE-2D107, NY, Court of Appeals, 2005. Friends, today we're going to talk about an organization I've never encountered before. So let us begin, as you may have encountered it. Third parties, third parties, third parties. We love you, third parties. Hence, we do what we can to learn about ballot access. This ballot access case involves an organization I never heard of. Maybe you have heard of it. So let's read from the record. It says, quote, as a candidate for the office of member, Dutchess County Legislator, District 16, petitioner Susan McGuire commenced this election law 16-012 proceeding seeking to invalidate the independent petitions nominating respondent Allison E. McAvery as candidate of the Senior Citizens Party for the same office. Finding a defect on several pages of the petitions, Supreme Court invalidated the petitions. The appellate division affirmed. End quote. Supreme Court, appellate court, appeals. Whenever you go to one of those, I applaud because that is taking it to the next level. Have you ever heard of the Senior Citizens Party? I've never heard of that third party. If you're from New York, maybe you have heard of them. Maybe they're outside of New York. I've never encountered them. I love to read about third parties. All the time I discover new things about third parties. Still, I've never heard about the Senior Citizens Party. Are they progressive in nature? Are they socialist, anti-capitalist? Are they on the left? What are they like? I imagine if they were in my area, I would consider voting for them, as most third parties, if not the vast majority of third parties, are in my consideration for voting for them. If Donald Trump starts a third party, like some people are talking about, then that will be one third party I oppose. Otherwise, I'm willing to vote for almost any third party. Dutchess County Legislator. That sounds like the county has its own legislator. So are they referring to the legislator of New York State? I would imagine so, but the way it's worded makes it sound like the county itself has a legislator. The decision continues, says, quote, independent petitions nominating Allison McAvery as a candidate of the Senior Citizens Party were timely filed with the Dutchess County Board of Elections. Susan McGuire commenced this proceeding asserting, among other claims, that the independent nominating petitions were invalid because several pages of signatures were obtained by a subscribing witness who was not a resident of District 16 and who had struck some of the language in the statement of witness that appears at the bottom of the pre-printed petition sheets. The signature pages include a witness statement containing language prescribed in Election Law 16-14, parentheses 1, parentheses B. The subscribing witness, John Ballot, struck a phrase that appeared in the witness statement, which read, and I am also duly qualified to sign this petition by drawing a line through these words, substituting the word omit and initialing the change. No explanation for the alteration was included on the petitions. At an appearance before Supreme Court, McAvery's counsel conceded that Ballot did not reside in District 16, representing that this fact explained the omission of language in the subscribing witness affidavit. McAvery contended that, despite the fact that Ballot did not live in District 16, he had a constitutional right to circulate independent nominating petitions on behalf of McAvery based on this court's decision in matter of LeBrake versus Dukes, which held that non-residents have a constitutional right to circulate designating petitions. End quote. First of all, I applaud them for filing their petitions on time. Way to go. We like that. When you file on time, it helps the case. What do you think about John Ballot striking out that phrase and putting omit on that? Have you ever changed a statement? I've heard legal experts say you can negotiate any contract, any legal document. You can negotiate. You can cross out things you don't like. I like that empowerment. So we maybe can consider that. I imagine in some cases if you did that, the other side would just say no. So still, we like what he did here. What do you think about having to reside in the district? Do you think that should be necessary to circulate nominating petitions? Fortunately for our side, this court ruled that in other cases you could reside outside and still do that. They state in this case the First Amendment guarantees that right even if they reside outside of a different state. So hooray for the First Amendment. Like I say on virtually all these podcasts so far, we love the First Amendment, we love third parties, so when the two combine, it's a higher level of euphoria. Can't imagine how high a level of euphoria it is. This case is not like some other cases. In some ways, it may be like other cases. They also say, quote, "We have long recognized that the witness statement is essential to the integrity of the petition process and have consistently held that the alteration of the statement, which is unexplained and uninitialed, will result in the invalidation of the petition sheet, even if the alterations resulted in the manifestation of correct information." End quote. So perhaps that's a lesson. If we are to alter the petitions, we want to add a reason why we are doing that. Right before that, they say this individual could have circulated the nominating petitions, so they do admit he had that right. So how would you have gone on about this if you were in Ballot's shoes? I am giving Ballot the benefit of the doubt. It seems like in his circumstance he did the right thing, all considered. They also say, quote, "We may not speculate as to what Ballot's motivations were or whether he was or was not otherwise qualified to circulate the independent nominating petitions. We are mindful of the dilemma facing otherwise qualified subscribing witnesses who cannot attest that they are qualified to sign the petition they are circulating because they do not reside in the candidate's district. In light of our holding, the statutorily mandated subscribing witness statement in election law 6.132 and 6-140 need to be revised for non-resident witnesses who wish to circulate designating or nominating petitions. We urge the State Board of Elections to take whatever action is necessary to determine how best to amend the pre-printed witness statement and to issue new petition forms. Accordingly, the order of appellate division should be affirmed without cause." End quote. So is that a defeat? Unfortunately, in one sense, yes, because our friend here from the Senior Citizens Party didn't get on the ballot. In another sense, it's a victory because not just in this election, but in future elections, they need to change election law to give more ability to non-resident petition holders. And that can help our case. I imagine it's difficult to find people to circulate petitions the way it is. So if you have the requirement they have to reside in the exact district, then that's going to make it even more difficult. So this is a victory. Furthermore, there was a dissent. One of the judges dissented. And he made some good points. He says, quote, "This is a proceeding by Susan McGuire, the Republican and conservative candidate for the office of Dutchess County Legislator, to invalidate the independent petition nominating Respondent Alison McAvery as candidate of the Senior Citizens Party for the Dutchess County Legislature. End quote. The Conservative Party is a third party. So that's unfortunate that McGuire here is invalidating that stuff. I'm sorry, not McGuire. Never mind. The Conservative Party rocks all the way. The way it's worded makes it sound like the Conservative Party candidate is preventing the petitions. It's the way it's confusing me, because McGuire is doing the suing. Whatever the case may be, we applaud them. Also says, quote, the requirement of the election law that a subscribing witness to a nominating petition live in the district of the candidate of the nominating petition has been declared unconstitutional. Election law 6-132 (2) require that a subscribing witness to a designating petition be a resident of the political subdivision in which the office or petitions is to be voted for. End quote. And he also states that freedom of speech is involved in the right to circulate these petitions. And he said they did this in other cases. They ruled that. He gives some benefit of the doubt to Ballot, that guy who had to strike out that part of the statement. It said, quote, thus, to swear that he is a person duly qualified to sign the petition, that he lives in the district, would amount to perjury. The fact that the Board of Elections or the state legislature has not changed the form during several years after a declaration that a portion of it is unconstitutional is not an adequate reason to deny the subscribing witness his constitutional rights. End quote. Yes, Ballot does have his rights. He deserves his rights. And he continues, it says, quote, he did not delete from the form the statement, I am duly qualified voter of the state of New York, and it can hardly be seriously contended that the state had any other valid reason for interfering with the exercise of his First Amendment right. Even if such a reason did exist, it was the state's burden to prove it, not Ballot's to disprove. He was within his right to strike the unconstitutional provision of the form. Accordingly, I would dismiss the application invalidate, declare the nominating petitions valid, and permit the candidate's name to appear on the ballot. End quote. In addition to, as he says, it's his right under the First Amendment, that part of the ballot is unconstitutional, that part of the petition is unconstitutional. So he was right in asserting that Ballot, our friend, could have legitimately struck that portion out. So friends, what do you think about all of this? Have you ever struck anything out? Have you heard of the Senior Citizens Party? How are you going to cheer for the victory we made in this case? We didn't win everything in this case, surely, but we did get a victory. Change in the law that helps our side out. So let us say hooray. Long live third parties. Goodbye.